and I work in the Madison office. For information about legal action, where our offices are located, the kind of services we provide, and how to access those services, you can go to www.legalaction.org. What I'm going to be talking about today is Social Security disability and SSI benefits. I'm going to start by describing the Social Security disability, which is also called SSDI, and SSI programs generally, and then explain some of the differences in the two programs. And then I'll discuss the disability determination and how that's made. So we're going to start with a question, and that's how many of you have helped someone with an application or an appeal for disability benefits? And you can just raise your hands for a quick count. Okay. Looks like a couple of you. So Social Security and SSI, Social Security disability and SSI, provide cash payments to disabled individuals. There are some similarities and there are some differences. Social Security disability is an insurance program for disabled workers and their dependents. So if you work and you're paid a salary or a wage, when you get your paycheck or your pay stub, you'll see something FICA. That is your payment of Social Security taxes into the system. SSI is more of a safety net program that provides support for low-income disabled individuals. And you need not be insured in order to get SSI, but you do need to be disabled to get either. The disability criteria is the same for both programs. You can't be engaged in substantial gainful activity, and at this point that means working in exchange for money, and there's a presumption that gross wages of $1,130 a month is substantial gainful activity. That changes annually, so it will probably increase, various amounts over the years. But if you are at that level that's established, then you are not going to be able to show that you're disabled no matter what your condition may be. The other requirement is that you be unable to engage in substantial gainful activity because of a medically determinable impairment, and that can be a physical or mental condition or a combination of conditions. And that impairment or combination of impairments has to be expected to result in death or last at least 12 consecutive months. And it is possible for certain conditions which are severe but can be reversed or corrected to result in what's called a closed period of disability, meaning that if it's going to last at least 12 months but maybe not be permanent, you would be eligible for a defined period of disability benefits, after which you would no longer be eligible. So before we move on to talk about the two programs and how they're similar and how they differ, got another question for you, and that is, do you know whether the value of your assets matters when you apply for disability benefits? You can go ahead and answer that question. Okay, looks like we've got some answers here. Most of you have said that the value does make a difference. And some of you said that it doesn't matter. And it depends on the program. For Social Security disability benefits, which is that insurance program I described, your assets and your income not from wages or earnings does not matter. You just have to show that you are disabled within the meaning of the law. For SSI, your assets do make a difference, and there is an asset limit. And if you're over that asset limit, you won't be eligible for benefits. So for SSDI, Social Security Disability Insurance, you have to have insured status, and that means working and earning quarters of coverage. And the general rule is, and it is a very rough rule, but if you have worked 20 quarters within the past 10 years, that's basically 5 out of the past 10 years, any time within that 10-year period, you're going to have insured status. And as I said, there's no income or asset test. You just have to have insured status and show that you are disabled. If you can show you're disabled and qualify for SSDI, a dependent child will also be able to get benefits, and a spouse in certain cases will also be able to get benefits. The amount of benefits that you receive is going to be based on your earnings record. The only time that your income matters with respect to SSDI eligibility is if you are actually working and getting paid for your work, in which case you've got to remain under that SGA amount. And the fact that you are working, even if you are under that SGA amount, may be considered in determining whether you are capable of working at or above that SGA amount. For SSDI, there is a waiting period for benefits. And the payment of benefits begins after it's been determined that you've been disabled for 5 months. Typically, awards are made sometime after you apply. So it's possible that you are a year past your application date. It's determined that you were disabled as of your application date. The first 5 months that you are disabled, you are not paid SSDI benefits. It will start with the 6th month of disability. SSDI recipients will also become eligible for Medicare, but not until they have been disabled for 24 months. Once eligible for Medicare, low-income SSDI recipients may qualify to have Medicare premiums or copays or deductibles covered by medical assistance. And that's based on income. And you do have to apply for that. Medicare, you will be offered the opportunity to enroll in automatically once you hit that 24-month amount, that 24-month waiting period. But if you want Medicaid assistance paying your premiums or copays, you do actually have to apply for that. There's nothing to keep you from applying for medical assistance during that 24-month waiting period, and you will have to meet the medical assistance financial eligibility criteria. Now, how many of you have helped someone apply for food stamps or Badger Care or W-2? You can answer by raising your hand. Okay, looks like a number of you. Well, the reason I asked that question is because those of you who have done that with other benefit programs may be a little more familiar with the factors that go into determining SSI eligibility, because in addition to being disabled, for SSI you have to meet income and asset limits. And at the moment, the income limit is the SSI maximum monthly benefit amount, which is $733 a month. That does change annually. There is an asset limit which has been in effect for some time, and that amount has been $2,000 for some time and probably will remain that for the foreseeable future. Now, it's possible that someone who's getting SSDI can also qualify for SSI, and that's because the SSDI is based on your earnings record, so you may be receiving a low enough amount of SSI that you would also qualify for, SSDI. You'd be receiving a low enough amount of SSDI that you would also qualify for SSI. In fact, because of the way income is counted, if your only income is SSDI, and at this point it's not more than $752 a month, you would actually qualify for SSI as well for $1 in SSI. The other thing to keep in mind for SSI financial eligibility is that the income of others in your household, a spouse, for example, or other income you're receiving from other sources, would be considered to a certain extent in determining your eligibility. SSI benefits are paid from the first month that you become eligible, showing that you're disabled and that you meet the financial eligibility requirement. And the amount of benefits that you're paid depends on your other income. Anyone who's getting at least $1 a month in SSI is also going to receive a state supplement, and that's normally $83.78 a month, although it can be more depending on certain circumstances, and that's automatic. In addition, a parent who receives SSI may qualify for a caretaker supplement for minor children living with that parent. And the amount of that caretaker supplement benefit is $250 a month for the first child and $150 a month for each additional child. Eligibility for the caretaker supplement does depend on a number of factors, including household income and other income coming into the home. But the SSI itself is not counted. A parent who is receiving SSI benefits must make an application for caretaker supplement benefits to the local human services agency in order to be determined, in order for an eligibility determination to be made and to receive caretaker supplement benefits if the parent is eligible. In addition, anyone who is eligible for SSI is going to automatically get medical assistance from that first month of eligibility. So as you can see, someone who's getting a low amount of SSDI and has his or her income supplemented by SSI is going to automatically also get medical assistance while they're waiting for that Medicare enrollment. And they will remain eligible for medical assistance even after becoming enrolled in Medicare after 24 months. Now we're going to move on to talk a little bit about the disability determination itself. And we've got another poll question for you, and that is, does it matter whether your doctor says you're disabled in deciding whether or not you will get SSDI or SSI? And you can go ahead and answer that question. Okay, we're getting some answers here. And the answer is that what your doctor has to say matters, but your doctor's actual opinion as to whether you are disabled is not a factor. Disability is a legal definition. So medical information, medical opinion as to a diagnosis, the effect of the diagnosis, limitations on the individual's ability to function do matter. But the doctor's ultimate opinion as to whether you're disabled or not does not matter. So in many cases, we do see clients who come to us for the first time with a letter that says this individual is disabled, but not a whole lot of additional information. And that's just not going to cut it with Social Security. So let's talk again about the criteria for establishing disability. The first is that you can't be engaged in substantial gainful activity, which is earning $1,130 a month or more for your work. You must have medically determinable physical or mental impairment or a combination of impairments. And you have to be unable to engage in substantial gainful activity because of the impairment of combination of impairments. And again, those impairments or that impairment has to be expected to result in your death or have lasted or expected to last at least 12 months. And your ability to engage in substantial gainful employment or activity is going to be based on a number of factors. Your age matters. As you age, the expectations for the physical level or how strenuous the work can be will be lower. Your education matters. Your work experience over the past 15 years, which is called your relevant work experience, is considered. The medical evidence of your impairments and the limitations resulting from those impairments matters. In addition, the jobs available in the national economy matter. You are going to be gauged based on your limitations against the requirements for various jobs that exist in the national economy. And you've got to be able to show that based on your disability and limitations, you are not able to perform a job in the national economy. Unfortunately, that can mean in some cases that jobs which do not exist where you live but do exist in abundant numbers in the national economy would mean that you're not eligible for benefits because they do exist somewhere else. I want to talk a little bit about what the terminology means in looking at the disability determination. We're looking at signs, symptoms, and laboratory findings. And signs are, abnormalities that can be observed and detected by medically acceptable diagnostic techniques. And that does not just mean blood test results or x-rays or lab findings. It also means accepted psychological testing and other kinds of testing that can be used to determine mental and emotional conditions and limitations. So I'm going to talk about that for a bit. Psychiatric signs, as the slide shows, are medically demonstrable observations that are going to indicate abnormalities of behavior, of mood, of thought, memory, orientation, development, or perception. And these should be described by medical professionals, physicians, psychologists, therapists, counselors, or social workers. It's important that you have a diagnosis for a mental condition from a physician or psychiatrist, but you can augment that with information and treatment records from other healthcare professionals. Typically, individuals who have mental health conditions or limitations may be seeing a therapist for regular treatment, and the therapist will consult regularly with a psychiatrist or another physician. But it's probably going to be the treatment notes from the therapist that flesh out the individual's condition and the limitations. And if those limitations can be tied to the diagnosis, then that's going to be sufficient to show that the individual is disabled. And here are some examples of what you look for when you're talking about mental health problems and treatment. Clients who are experiencing anxiety or depression or PTSD or other conditions that result from trauma or abuse or witnessing abuse should definitely seek psychiatric or psychological care. And it's important to seek treatment and go ahead with ongoing treatment, because if treatment is prescribed and an individual does not pursue that treatment, then that's going to be a factor in determining whether the individual is disabled. And an individual who does not, for a good cause, who does not have good cause for not following prescribed treatment or recommended treatment, is not going to be found disabled. As I said, treatment notes, records of treatment or meetings with therapists and other treatment providers are going to be very important in order to flesh out the limitations and how the individual functions. In addition, the fact that an individual has been prescribed certain medication is also important, because you can sort of back into what that medication is prescribed for to show the limitation and the severity of the limitation. So what an individual has to show is that he or she can't perform prior past work or similar work, past relevant work, or perform other low-stress, routine, or unskilled work. And that can be shown through various means. And this is where we look at both the medical evidence from the physician, the diagnosis, the test results, the acceptable methods of identifying conditions, limitations, and the treatment notes, and we tie that to more day-to-day practical considerations. How do the limitations that have been demonstrated affect the person's ability to function? If somebody needs to feel safe in terms of both the physical setting and the atmosphere of a work setting, that's a factor that needs to be considered in determining whether that person can work and what kind of work that person can do. The ability to deal with the give and take of a work setting, concentration, staying on task, and missing work, whether it's because of a work-related event or because of a personal event related to the disability. Those are all factors that are going to be considered. In looking at this, the observations of friends and family and coworkers and of work supervisors can be very important in showing whether or not the individual is capable of working. A coworker or a supervisor can talk about, an individual's reaction to certain situations and how that makes it difficult to keep that person employed, or how it makes it difficult for that person to perform the job. The same is true of a family member or a roommate or friend who sees you frequently and who can talk about how you function. You don't leave the home. You don't like to talk to other people. If it's not someone you know who comes over to the house, you go into your room and stay there until that person leaves. Your tendency in some instances to act in a manner that may seem unusual to others when you go to the store because you want to avoid contact with people, or you want to avoid what you may perceive to be confrontation. Social Security will make the determination, the disability determination, based on the signs, symptoms, and other medical findings. And that determination is going to be made by the Social Security Administration, not by the healthcare provider. So going back to that earlier question, an opinion that an individual is disabled from your doctor is not nearly as important as what your doctor has to say about what test results and other acceptable methods of evaluating a condition show about you, your condition, your ability to perform certain tasks. And again, this isn't about can do work or can't do work. It's about specific things, specific activities, day-to-day activities, work activities, following instructions, and stuff like that. Before we go to questions, I just wanted to talk a little bit about the application process. You can apply in person at a Social Security office, and you can have somebody with you to help you do that. You can also apply online at SSI.gov. And SSI.gov is actually a fairly helpful site to go to just get general information about Social Security disability and SSI benefits. When you apply, you don't have to go with all of your medical evidence, and you don't have to submit all of your medical evidence, but you should be prepared to provide information about your healthcare providers, contact information for those providers, and you will be asked to sign releases and consents for release of information so that Social Security can obtain information from your healthcare providers. You should also provide information about others who have knowledge about how you function, how you operate day to day, so that that can be related to the diagnosed conditions and treatment notes and the like. Typically, only about a third of applications are approved at the initial application stage. If you're not approved, you do have the right to request reconsideration, and that's a paper review. They'll take a look at all the records that they already have, any additional information and records that you provide, any new treatment information, and make a new decision on that. There's a very low approval rate on reconsideration. It's less than 20% of the cases that go to reconsideration. And then finally, if you lose at the reconsideration stage, you can request a hearing with an administrative law judge. Those are done either in person or by video conference. And of the applications of the denials at reconsideration, so you see we're going to smaller and smaller populations as we go to each step. Almost 40% of the appeals to an administrative law judge are approved following an administrative law judge hearing. The time it takes from the time you request a hearing to a hearing, though, can be a year or more. Once you're approved, if you are approved, cases are reviewed periodically. And that depends on how the case is. They're called cases diaried by Social Security. And that's called scheduling it for continuing disability reviews. And that's based on the nature of the disability. The notice of award that you receive will typically tell you when you can expect your first review, and they occur in cycles of 3 to 7 years. If medical improvement is possible, if Social Security determines medical improvement is possible, you're probably going to be reviewed within 3 years. If medical improvement is expected, that review will be sooner. And something like a low birth weight baby, where there's an extreme condition at the time of birth, but depending on any number of factors, the impact over time may minimize. That may be reviewed a little sooner than other cases, and that's just one example. And finally, if medical improvement is not expected, and that would be in the case, for example, of autism, multiple sclerosis, cerebral palsy, or Down syndrome, situations like that, there will be reviews, but they will be further down the road, for example, after about 7 years. For children, however often they're reviewed, there will be a review at age 18 to determine whether the individual remains disabled. That's all I have to say for now. I'd be happy to answer any questions people have and explain anything that I may not have explained too well.